Does this count as floral? It's got designs. I'm not sure if it counts as floral though. The song we've been waiting for. Good morning, everybody. Good afternoon. Hello, 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 wherever you are. The stream is officially live. And the dogs are officially going to go nuts. Yay! Oh, wow. We're going to listen to our opening song. We'll get this thing started. Give anybody a chance to get joined in if they want to join us in. his space being a cat. Dogs are running around being dogs. And the wolf is here being a wolf. Good morning, everybody. Good afternoon, good day, good evening, wherever you may be. It is wonderful to see you. See your cat message. Woo. Hey, it's not just your first Wolfie Live. Well, it's not the first Wolfie Live, but it's the first official weekly Wolfie Live. So, welcome. We're all kind of in the same spot. Get you some good grubs on there, Rachel. Get some good lunch. I guess it's technically kind of brunch. Wolfie's Live. Well, hello, everybody. I'm not going to beat around the bush. I'm not going to have a long monologue intro. We just listened to some music coming in, getting ready for the stream. I do want to kind of set up what we're going to see today. It's going to be 3 segments. Normally I do kind of isolations of individual hearings. So this is actually going to feature 3 judges and kind of segments of different portions of their dockets. The first we're going to look at is Shackelford from Thursday. She had a couple of real interesting in custody hearings, and she followed it up with a real interesting, what I thought was an interesting probation violation hearing. The second thing we'll look at is some Simpson. In the Simpson, we got kind of a special little block for the Simpson block. We're going to start that off with a hearing from Wednesday that features Pill versus Geller. You may remember Miss Geller as the Wi-Fi, the allergic to Wi-Fi lady. So they're back. And I also have a couple of other feel-good clips from Simpson from yesterday's Landlord tenant docket that I happened to see, and they just kind of, I saw them and I was like, I like these. I'm gonna isolate these, put them off to the side. The last thing we're going to watch today is going to be Judge Boyd, and man, we got some. We got Judge Boyd being Judge Boyd and bringing the gavel down on some people who just cannot get the message the first time, or the second time, or the third or fourth or fifth time. Anyway, all that being said, I'm going to go ahead and get things started here with our very first segment block with Judge Shackelford. And let's watch some Judge Shackelford together, shall we?
Who's first?
Mr. Marshall first. Mr. Marshall, come up to the door.
His mother in the courtroom.
All right, this is the People versus Theodore Marshall.
Good afternoon, Your Honor. Jeffrey Fant on behalf of Mr. Marshall for limited purposes of arraignment. We wait for all reading, stand mute.
I'll enter a not guilty plea on his behalf. Mr. Marshall, you have a right to remain silent. Anything you say orally or in writing can and will be used against you. You also have a right to have an attorney present during any future questioning and any future court hearings. If you can't afford an attorney, one will be appointed to represent you. And I'm signing the order for appointment now. You have 2 court dates within the next within the next 21 days. The first is your probable cause conference. That will be via Zoom on 4/8 of 2024. The following week on April 15th of 2024 will be your preliminary exam. On that date, the prosecutor must show that a crime was committed and probable cause exists to charge you with that crime. Do you understand that? Do you understand that? Is that a yes or a no?
Yes, Your Honor.
Oh,
Yes.
okay, thank you. I have to be able to hear you for the court reporter. All right, Mr. Fanch, what's the bond?
Judge, no history, no holds. His mother's in the courtroom. The address, which is a new address, is where he'll be residing. And I've explained the court's contact provisions to him, and would request a personal bond on this matter. And I spoke with his mother earlier today, and she's back here this afternoon.
These are very serious allegations.
They are, Judge.
The 15-year felony.
We have two 19-year-olds, Judge.
Is that Pine Street where the two of them were residing, or is that? Are there children in common?
Yes.
They're married?
Yes.
All right. All right. And ma'am, can you stand and say your name real loud?
Marshall,
Can you spell your first name?
March.
Okay, and then Marshall, Marshall.
Yes, Your Honor.
All right, and this is your son?
Yes, Your Honor.
Is Mr. Marshall able to reside with you?
Yeah, sure.
He'll be with you because he can't go home.
With me in my home or with his dad in his home?
All right. I'm having him stay with you
Okay.
because he's going, do you have a landline?
Yes.
All right. I'm giving you a $75,000 personal bond with a GPS tether. I want to be really clear. I know the attorney told you, but Mr. Marshall, you're young. If you mess this up, I want to be clear. You will sit in the Wayne County Jail, and it is not nice. If you don't like it next door at Taylor Police Department, you're going to hate Wayne County. If you do not follow my no contact order, you will sit in Wayne County for weeks at least. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. You can have no contact with Kashmir Randall, zero contact. That means you can't call her, write her, email her. You can't send her anything through social media. You can't comment about her on social media. You can't have anyone else do any of these things except for your attorney. You can't send her blank messages. You can't use apps on the computer that allow you to generate phone numbers to contact her. This is an order. If it's going to be changed, I will be the one to change it at a future court hearing when both parties are present. If you see her at a party store, or if you see her at a barbecue or at any sort of event, a store, you're to turn around and walk out immediately. Do you understand me?
Yes, Your Honor.
If you violate this order, you will sit in the Wayne County Jail. I will turn that $75,000 personal bond into a $75,000 cash bond. You're not to enter the premises at 12707 Pine Street. I will allow you one visit to obtain personal belongings if you are accompanied by a police officer. You can't possess or have access to firearms. You cannot purchase or consume alcohol or illegal drugs. And those are the terms of your bond.
Judge, it will likely, given the time and the weekend, it'll likely be Tuesday, maybe Wednesday before he gets released.
I understand that, but I'm not comfortable. I'm giving him a personal bond on a 15-year felony assaultive case. He's getting the GPS tether.
Thank you.
All right, sir, sit tight for a bit.
Wait, can I say something, please?
Sure.
Your Honor, please.
Officer Ziegler, we'll need that form signed, please.
Okay. Just have her come over to the front desk.
Thank you.
Thank you.
No.
All right, Your Honor, we're gonna give Mr. Whitler a shot again today. His attitude hasn't changed.
Does he have pants on?
He does. He's missing his shirt today.
That's okay, I'll take it.
All right, Mr. Whitler, come on up here to the door. Mr. Whitler, come to the door, please. There we go. Fully dressed, that's perfect.
Thank you. Good afternoon, Mr. Whitler. Sir, you've been brought to court on a misdemeanor charge. There are two. There's interfering with a police officer and a larceny case. Both are misdemeanors punishable by up to 90 days in jail and a fine of up to $500. On the larceny, it could also be 3 times the value of the property. You have a right to an attorney. If you cannot afford an attorney, one will be appointed to represent you. You have the right to a trial, and at that trial, you have the following rights: to call witnesses to speak for you at trial. You can get an order signed by the court to require witnesses to come to court. You have a right to see, hear, and question all witnesses against you at trial. You have a right to be a witness for yourself or to remain silent. And if you chose not to be a witness on your own behalf, the prosecuting official could not comment on your refusal to testify. You have a right to be presumed innocent unless proven guilty beyond a reasonable doubt. You also have a right to a bond. Mr. Whitler, is there anything you want to tell the court with respect to a bond? Seeing nothing? Here's the thing, Mr. Officer Ziegler, I'm holding this arraignment. If he refuses to participate, I'm not going to call him back every day. At some point, we have to have a hearing. And if he doesn't want to participate in it, that's his right. But that's what we're doing. So it was read on the record. I'm indicating that Mr. Whitler refused to come to the door and lay down in cell. We tried this yesterday. We'll do it forever. Mr. Fanto, I'm going to ask you to stand in as standby counsel here. I know that Mr. Whitler's refused to talk to either of us, but with respect to bond.
Judge, I don't have any confirmation of his address, showing on the files a Toledo address. The, here are my notes. He has hold Southgate and Allen Park. And it looks like his last conviction was a 2021. If the court's not inclined to do a personal bond, I'd ask for it to be marked medical for mental health evaluation.
Can you approach real quick, Jeff?
Your Honor, we done with Mr. Whitler?
We are done. Yes, thank you.
Well, what do I put for a bond?
His $500 cash bond and his file will be marked navigator for the mental health program in the Wayne County Jail, mental.
All right, thank you, Your Honor. You have a great weekend. Good holiday.
Yeah, you too. Thank you. All right, Anthony Terry.
Good afternoon, Your Honor. Probation.
Good afternoon, Your Honor. Jeffrey Fanto on behalf of Mr. Terry. I spoke with Mr. Terry, prepared to interplead guilty to the first two allegations. The missing the testing date, Judge. The he had called, he indicates that he spoke with the testing folks. They were apparently late updating in that particular day. So he won't admit to that. He'll acknowledge the first two. He understands he has a right to have a hearing and is prepared to waive that right.
Okay. We'll get to the third one in a minute. So you understand it's your fourth technical violation? I could just put you in jail
Yes, ma'am.
for the, whatever the maximum was at this point. You understand that?
Yes, ma'am.
Did you go over your advice of rights form with your attorney?
Yes, ma'am, I did.
Did you understand it?
Yes, I did.
And did you sign and date it?
Yes, I did.
You understand, Mr. Terry, that if you enter a plea of guilty, that you'll be waiving your hearing rights. There will be no hearing of any kind.
Yes, ma'am.
And is it still your desire to plead guilty knowing that?
Yes, ma'am.
Did you fail to attend treatment as directed by therapist?
Yes, ma'am.
Did you fail to attend community service on March 2nd of 24?
Yes, ma'am.
Okay. When you say fail to attend treatment as directed, did he miss an appointment?
Yes, Judge. He was.
One, he missed one appointment.
Then
Two.
he rescheduled it, Judge.
One with a therapist, one with a psychiatrist. The therapist had to be the one to call him. She called the next day on 3/6. He said he'd call her back. As of my appointment with him on 3/14, he still did not reach back out to the therapist to reschedule.
What are you thinking?
I thought there wasn't a plan set with her at that time because my therapist has switched twice now, and I screwed up.
Mr. Fanto, what are your thoughts?
The therapist switching is a problem that we certainly understand that is happening from time to time. He wasn't sure of the plan, and I had a conversation with him that whenever he meets with Ms. Havner or myself or the court or his therapist, his last words when he leaves those is to make sure he understands everything each party wants. And for his therapist meeting, it's okay, my next appointment is on such and such a date, is that correct? So that he, does that. He didn't check his email because he's in a job search situation and gets a bunch. And so I offered a workaround for that, and he's going to create another email for his court-related matters so that he can keep track of those much more easily. Just a little bit of organization. I don't think it's a intentional thumbing the nose, but it's just a little bit of organization.
What were the prior violations?
The first one was increased levels of testing. The second one.
I mean, what the violate, is it just okay, let's see.
I think he got community service for the first violation. He got court watching for the last two violations, but they have been due to testing. Either increased levels the first one. I think the second one was he missed a test, and the third one he took CBD gummies.
Mr. Terry, you're sitting here, you've sat here and done your community service. I generally think I'm pretty reasonable,
I agree with you, ma'am.
right? I'm not out to get anybody.
No, ma'am.
I mean, I treat everybody that comes in here fairly,
I agree with you.
but like you have to recognize, like, this is not, you're on probation and you're an adult. Like, it's not our job to make sure, I mean, you'll get violated if you don't do all the things, but Kelsey's not your nanny. Mr. Fanto's not your nanny. Your therapist isn't your nanny. Like, this is your responsibility.
Yes, ma'am, I understand that.
And there are certain benefits you get out of this, and I expect you to take advantage of them. You're gonna go, I mean, you can't just cancel these appointments. It drives me crazy. At the guidance center, do you know how many spots the guidance center holds for us so that people that are in my treatment court program or on probation here can get services? And when you don't show up, they've taken an hour of their time, right? They can't schedule anyone else when you don't show up. They can't call someone and say, hey, come right now, I'll see you now. Like you have the privilege of being at this court where we can get you in fairly quickly. right?
Yes, ma'am.
But that is so inconsiderate of professionals' times to not show up to those appointments. It's frustrating for them. It harms other people that come into this court, because if nobody ever shows for their appointments, how many appointments are they going to hold for our people?
You're right.
Like it's out of respect to these people that make time for you and understanding, like, there's no one else. It's not McDonald's. There's not someone else in line, right? Like, they can't just open their door and be like, well, I guess you come in. That's not how it works. It's an appointment with a medical professional. You have got to show up for those. It is so disrespectful
Yes,
to
ma'am.
not.
I would note that he reports that he tested the next day, after he missed the test.
Yes, he did.
On the 321 test?
Yes.
So they were a little late to updating the colors. However, the date from, it said 320 instead of 321. So Mr. Terry should have been aware that it was the wrong date. And there's also a website that they can
Yeah.
check.
Yeah, but nobody, I mean, Kelsey, like, I get it, but nobody, if I had to call a number every morning and I call the number every morning and it's like, today is the such and such a date, these are the colors. I'm just listening for tan. I'm just listening for scar, like, I get that, like,
And
it is your responsibility, but ultimately, like, if you went there and you checked and it said you were good for the day, I wouldn't expect anybody would listen to the day.
yes, ma'am. I also even sent Miss Kelsey a screenshot of my call log, and I asked the guy downstairs what happened the day before. And that's, he said they were updated late. That's why I missed, on the 21st.
All right, I mean, I can't hold that against you. I mean, and really, the most problematic thing for me is you have to go to these appointments,
Yes, ma'am.
because it's not just our time. Have you been
Understand.
lectured enough? Do you understand how important it is?
I do.
What's his work schedule? The recommendation is for a day of jail forthwith, verification of an appointment within 7 days, continuing as directed, and all other conditions would just continue.
Well, I think you already have your appointment set, right? Your next therapy appointment.
Yes, ma'am, I do. It's, April 14th, I wanna say. I got the text on my phone.
And you can provide that to Ms. Heather.
Yes, I can.
Have you seen it yet?
No, I have not.
All right. So
Good.
for the,
He does work tonight, but
I work Monday through, Friday. And I'm off, Friday afternoon, cause I work the night shift, and then I'm off Saturday, and then I go back Sunday.
has he done any jail yet?
No, Judge. Yeah, the first sanction was community service. The last two were court watching.
is the garden starting up soon, Judge?
April 20th, Saturday.
Saturdays are good days for him to do that sort of thing.
This is your final. I mean, you should get some jail time. When did he get put on probation?
I believe it was right before the holidays, so it was sometime in December, I wanna say.
Oh, this was his 8/16/23. Oh, that's when he was referred. Did
Um,
he go into warrant status? Yes, he did. Mr. Perry,
I could be wrong about the date, Judge, but I believe it was, I believe I had ordered sometime right before the holidays, but I could be mistaken.
it was October.
Oh.
October of 23. You're on your 4th violation. I've given you additional community service. So one was driving when you weren't supposed to, the CBD, which I do think the numbers were at like consistent with that, right? On the gummy or whatever it was.
Yeah, he admitted that he used it, he just thought that it was THC
Yeah.
free, but we had the discussion, he's responsible for what he puts in his body.
All right. This is it. Next time you're going. 2 days community service plus 420 at the garden. So that's 20 hours of community service. You're gonna provide verification to Kelsey of your next therapy appointment, thank you, within 7 days. And all the other conditions will continue. And all of that garden time and community service must be completed. He could do Saturdays, right?
Yes, ma'am.
All right, so he has next 2 Saturdays?
For DPW,
Yeah,
yes, I can put him on.
next 2. I mean, I don't know if they've got time or to add them for this week, but if not this week, the following 2. I don't know if they're doing it over the holiday week even.
Judge,
know they're
I
not
was
ready.
scheduled next, not this following, but the next Saturday anyway, so if that,
Yeah, I mean, that doesn't count. You
That's
have
what-
to
that's what I
do
was
20, you have
expecting.
to do 2 days in the next 3 weeks, right? The
okay,
next, not this Saturday, the next 2 Saturdays plus 420 at the garden. And that, I mean, this is in addition to your regular community service. So it's not going to count towards your hours because it's a sanction.
I understand that.
All right. All right, we're all set.
Thank you. So that's you can send it out.
I'll call him because I have like,
Okay. That is the Shackelford segment. Next, we're going to have Judge Simpson. It's 2 separate blocks. The first Judge Simpson block is from Wednesday, like I said earlier. It is going to be the Peel versus Gerler. Miss Gerler is, as I stated earlier, our defendant who, well, yeah, the tenant / defendant who is allergic to Wi-Fi and wasn't able to come to court. In the second part of the Simpson segment, we'll see a couple of landlord-tenant matters where I just liked the way these hearings went. So I thought I'd throw those in for a little feel-good segment. And then after that, we'll move on to Boyd. So, yeah. Without further ado, Judge Simpson and the weird civil case.
Pamela Peel versus Nancy Gerler.
Your Honor,
Okay,
Nancy Gerler, appearing on phone Zoom.
All right, and where are we on this case?
I believe that Hawk was still out there to help me with this money judgment. And I checked
They
back
won't
in with
help you.
Hawk. They, Ms.
Ma'am, they
Peel had
won't
not,
help with the money judgment. They will help you maintain your tenancy by paying if you're gonna remain in the unit, but you're out of the unit now.
sir, Ms. Peel did not return the calls on December 19th or January 3rd from Hawk, reaching out to her to try to assist with this situation. They closed the case. There might have been help from them and their affiliated agencies, but there are 4 occasions when I attempted to get help from other agencies, including the Department of Health and Human Services, when the situation where fraud might have been done in the name of another tenant wasn't cleared up for me either. So no, I do not feel that I owe the full judgment here. I
Then here's what-
have done
All right, that's
everything
fine.
I could.
Ma'am, that's fine. So here's what I'm gonna do. I'm gonna set this for trial. Both of you need to appear in person. And I'll just have a trial. You guys need to bring all your paperwork. Because what you're explaining to me, ma'am, would be rental assistance if you were going to stay in the unit. You're no longer in the unit, but you feel that you don't owe the money. If you don't owe the money, then that's gotta be hashed out and we're gonna have a trial. Emily,
March
7th at 9 AM.
I'll set your non-jury trial, March 27th.
27th.
2024, 9 AM, that is in person at the courthouse.
Your Honor, you do realize that I have great difficulty being in Wi-Fi and all of the.
You have
things
great
that are-
difficulty in what?
In being in your courtroom because of all of the electromagnetic frequencies in your vicinity as well as the courtroom. That's why I'm on phone Zoom every time. I
Ma'am,
suffer
I'm
physical.
setting it in, ma'am. I'm setting it in person. If you send me something medically that may make me change my mind, then I may let you appear via Zoom, but I'd have to have something from a doctor that the court can check out. Otherwise, I will expect both parties in person.
Yes, Your Honor, I will present to you that evidence and I
accept-
appreciate your consideration and.
I'm making it
Sir, sorry.
right now that this is set for non-jury trial in person.
Pamela Peel versus Nancy Gerler. If people kind of get out of your way, go ahead. William, state your name, please.
Good morning, Your Honor. Pamela Peel.
All right. Miss Gerler, are you there?
Yes, I am, Your Honor. I am present. Thank you.
Okay. Can you state your name for the record, please?
Nancy Rose Gerber.
Thank you. All right. Have you seen? All right. Have you two talked at all in terms of resolving this? Or where are we on that?
No, we have not.
How much is your claim?
I'm requesting a money judgment of $12,406, which includes unpaid rent of $12,950.
12,900.
Out-of-pocket court costs.
Hang on, give me the rent again.
Oh, yeah. $12,950.
Okay.
Which is on the balance statement that I gave Nancy Rose. Out-of-pocket court expenses, $215, court serving fee, $68. And then after we inspected the house and stuff, I added cleaning fees of 5 hours at $20 an hour, 2 extra days rent at $34 a day. And to the amount of, that totals $13,401.
$13,401.
I then deducted the security deposit that she had
Okay, which was how
for
much?
$995. And
How much?
it's up to $12,995.
How much was the security? All right, and then that's how you get to the 12,406.
Yeah.
Okay, so out of the gate, you're going to have to add $2.55 because the service fee, as the court has it, is $70.55, not $68.
Oh, okay. Oh, I thought it was,
The
okay.
what's also going to come off of the total amount is going to be the 5 hours of cleaning.
Pardon?
The 5 hours of cleaning. So the $100 that you put on for cleaning also it needs to be deducted.
From the security deposit? Or I
Probably
put
don't
it
want
in
to
the-
do it that way, but it's going to have to be deducted off of your total.
Oh, okay, so I can't do that.
Can't do that
Okay, all right, that's fine.
that way. And then the 2 days of rent, that was for what?
Nancy Rose was unable to move out on the 31st as the judgment requested, and she stayed till midnight, February 2nd.
Ms. Gerler, do you agree with that or no?
No, Your Honor, I do have some comments regarding what
Well, I
Ms.
understand you have comments. I'm dealing with just this issue. Were you there the 2 days beyond the 31st?
I was there the 2 days beyond the 31st. It was my understanding I had up to 10 days to vacate, and did not believe that there would be an additional sum for those 2 days, which were spent cleaning, and professional cleaner did clean the house on
Okay,
2
okay,
occasions.
it's fine. I'm dealing with this one by one. And so I'm just telling you. You're saying you did occupy the unit those 2 days?
Yes,
For
I
whatever
did.
the reason. Okay,
Yes, you're,
all right. Okay. Now I'm gonna ask a general question, Ms. Gerler, and I need a very, not a highly specific answer, but just this. Of the $12,406, is there any amount of that you believe you owe?
Your Honor, what was in contest at our last hearing was my stated concern that I had enlisted the help of Miss Biles at Faith in Action. And we could have been brought current at the first problem, and it was just shy of
Ms.
$3,000.
Gerler,
Sir, I just want to.
listen very closely to my question. Of the $12,406, which is primarily consisting of rent, is there any amount you believe that you owe or admit that you owe of that amount of rent?
Sir, if we were able to subtract the 3,000 she might have gotten, yes, then I would say that I am responsible for the balance.
So what your claim is, and is that if the 3,000 had been paid by the outside agencies, what you would owe at this time would be the $9,406.
If that is the
Right?
balance, Your Honor, yes.
Okay.
Veronica, when I talked to when Faith in Action approached me, they offered $800
How much?
1 month. And nothing was.
They offered
right-
what?
They offered 800 toward her rent. for
Right.
1
What?
month. That's all
I
I knew about.
understand, but what I'm getting at is, and I think what Ms. Gerler's getting at is, had Faith in Action plus what would have been the other agencies of Hawk and the like, she would have gotten a maximum of 3,000. I think that's what she stated the last time. That's what she continues to state at this time.
Okay.
All right. So
And
while she's pointing to one agency, I understand what Ms. Gerler's indicating, that there's this other agency. All right.
May I respond to that?
To which?
To the $3,000
I
offer
don't,
that I.
okay, first of all, here's the problem, ladies. You're fighting over stuff that doesn't make sense to me right now. Okay? And let me tell you why. Ms. Gerler admits she would owe the 9,406 in essence, and I appreciate her candor on that. There's now going to be argument over this 3,000 that Ms. Gerler says, because you're saying that they were only going to pay 8. I get where Ms. Gerler's coming from, because what I just said. Here's the problem with all of that. The problem with all of that is there would have been no payment with these programs if the tenancy wasn't going to be maintained. So the 3,000 wouldn't have come in. But I understand Ms. Gerler's point that, okay, it may have come down to this point, but if you had taken that money at this point, then I'd be 3,000 to the good, basically, is what she's indicating. All right. So let me just,
I never got anything in writing to that effect. And they never
Okay,
said that to
so-
me over the phone. I didn't know about Hawk. I didn't know about any of them.
okay, I get that.
Okay.
What are you guys really fighting over?
I just want to be paid the rent that I'm owed.
Okay.
And that she promised to pay each
Okay,
month.
and Ms. Gerler,
Yes, Your Honor.
are you working?
Not at present, Your Honor.
All right, and so
I only have Social Security income.
that's what I thought. You have Social Security,
Yes,
the SSD or SSI? Which one?
SSI, sir.
Okay,
I'm 68.
and got it. So how much is that per month? There's a reason why I'm asking.
$1,137 monthly, Your Honor.
137 a month.
1,137.
Yeah, I got it. I
Okay.
probably got it. 1,137 a month.
Correct.
Okay. So I can sit here through a trial. You can put on your proofs. You can do whatever. She's admitting basically to almost 3/4 of what you're saying anyway, right? Because if she's admitting to the 9,400, the 3,000 may be a question, but I've said what I've said. But here's the bottom line and why I'm trying to figure out entirely why we're here. And let me just, and I'm going to do this just in terms of the practicalities of it. All right. We can go through the trial, and I don't mind. You guys have my time. I can sit here through the trial. The cold-hearted reality of it is Miss Teagle, you come down to the end, and let's say, just by hypothetically, and I'm not saying this is the way I'm finding, I find entirely in your favor. And I give you that judgment for the 12,000 plus. Let's just say I do that. How do you intend to get that money?
Your Honor, it was a matter of principle.
Okay, I understand. There are principles all over the place, and people can fight on principle or whatever. My question is how would you intend on getting that paid? You told me you want the money. I get it. But how are you going to get that?
Well, I don't know, but I also make about the same amount of money in Social Security as Nancy Rose does. And that income was I depended on. And I worked hard and
I appreciate all of that.
Okay. Just one.
I'm just
say
getting,
no.
no, I know.
I'm not rich.
I'm not saying that you are. The reason I asked about her income is because that's where any judgment you would get would come from. Right? But you can't garnish her SSI until potentially at least there's an argument that it would be transformed into something else. If that's indeed all her income, go ahead.
Well, I know Nancy Rose is a psychic and she does a lot of readings in the past. And it's not always, above board. So she does have other income, which I never wanted to bring that up.
So okay. What do you want me to do? You want me to give you a judgment for the full amount?
I don't ever expect, I mean, she gave me her word that
Okay,
she would
I
pay.
asked a question.
don't
How come nobody
expect-
just answers my question? Do you want a judgment for the full amount?
I
We want to
do.
sit here through a trial? I mean, if that's what you want to do, let's do it. I mean, I'm trying to just give both of you the practical realities of it. That's all I'm trying to do. But if you want to sit here and we just go through the time of doing it, that's why I'm here. Let's do it. Mr. Allen, swear her in. I mean, it makes no sense to me. It's a waste.
Really?
It becomes a waste of time that you two can't resolve this.
May I speak to my husband for 1 second?
You want to speak to
My husband?
your husband? Go for it.
All
Go
right.
ahead. Talk to him. All right.
I will accept the $3,000 that you're proposing.
The 3,000 deduction.
Yes.
Okay. Ms. Gerler, did you understand what plaintiff was indicating?
Yes, Your Honor, and that is a
Yeah.
satisfactory conclusion. Thank you.
All right, so I'm going to enter a judgment total amount. So here's what I'm going to do. I've got your total figure, but the way that it would add up is, can you do this for me? Actually, it's going to be 70, 55. Okay, $9,406.
Your Honor?
No, that's not right. Hang on one moment.
Okay.
I have rent. Let me just go through the figures so that we're all clear on everything. So I'm going to have a total rental amount of $12,950. But
Your Honor,
where
that's
I'm
not
gonna, but hold on a second. Hold on a second. Where I'm going to take the rental amount off, the 3,000 off, is I'm going to take it off of that figure.
Your Honor, the rent figure given is not accurate. It
Which
should
part
be-
is not accurate?
The rent itself did not come to 12,900. Should be 11,900 and the change, not 12,000. That's adding another month's rent that was not applicable because she received the security deposit.
Well, no, I haven't gotten to that deduction yet.
Oh, I'm sorry, sir.
Okay, so just let me get through the figures, and then if anybody has a dispute, given what you've said, then we'll do it that way. So what I'm gonna do is, I've got a $12,950 for rent. I'm gonna deduct the 3,000 that we were talking about at that point, okay? This will probably make it easier. So now I'm at 9,500, or I'm sorry, no, 9,000, $9,950. Okay, everybody with me so far?
Yep.
Yeah.
I'm then going to add to that figure. There is going to be 2 days of rent at $34 a day. So I'm going to add 68 to that figure. So then I'm at 10. You with me, Emily?
I'm sorry.
You're not with me? Will you pay attention to?
I am paying attention.
Okay, take 9,950 plus $68, because I'm just gonna get the rent part out of the way. I come to 1018. Okay, so then I come to $10,018.
I thought it was $10,301.
Hold on. No. Everybody just stay with me in my math, okay? I took the 12,950, took off the 3,000 we talked about. That brings me to $9,950.
Mhm.
You're also claiming $68 of rent.
Okay.
That brings the figure back up to $10,018.
Okay. Then the court fees?
Ma'am, please. Without talking, just let me get through it and then we can back it off. Then I'm going to subtract out the security deposit, which was how much?
$9.95.
That's right, Miss Gerler. It was $9.95, correct?
That is correct, sir.
All right. So then, Emily, help me. I come to 90.23.
Sounds good.
Okay. That then is the total judgment amount, and now I'm going to add the cost in. And the costs that are added in that the court has is $215 plus $70.55 service fee for $285.55. Add those costs in, I come up with $9,308.55. That is the judgment amount and how I figured it. To the plaintiff, that figure is acceptable to you?
Yes, it is.
Ms. Gerler, is that acceptable to you?
Yes, it is, Your Honor.
Wonderful. All right, so what I'm gonna need, yes, ma'am.
May I ask Nancy how she intends to pay that? Or if she, and what time frame can I expect?
Well, let me do it this way. Ma'am, did you want to enter into a payment plan at this point? Or do you want the judgment to enter and then you can file for, she could try to collect and then you file for, come back, and then I have to decide what the payment is? How do you want to do that?
Your Honor, there's no commitment that I can make at this time. I am not working. I have lost all the phone numbers affiliated with my business. I have had chronic problems with chronic illness and even finding a permanent place to live. I
Got it.
certainly hope
Okay.
this changes in the future, and I will make every effort to pay towards, but at this point I can make no commitments because I literally do not have it, nor secure or stable additions to the Social Security income that I get.
Got it. So what that means is that you're left to the
Okay,
collection procedures that
All
you
right.
can.
that's
The
fine.
court will enter a judgment. Judgment amount is $9,023. Cost of $285.55 for a total amount of $9,308.55. All right.
Thank you.
You'll need to fill out a money judgment form out at the counter, and then once I get it, I'll sign off. Harbor One West versus Rosa Bannock.
Cheryl Wolkoff on behalf of the plaintiff.
Hello. What's your name?
Bannock.
Okay. Well, we've done some things on this. Where are we now in this case?
So, Your Honor, this is one where we had agreed to move the tenant to a new unit. I had asked for escrow to be released, and you told me we needed to trust you, and you were going to be like the IRS. Do you remember? Okay, so.
I do. I do.
Okay, at this juncture, I know, and Amy can speak more to this, Amy too, that they've been trying to reach Ms. Bannock and have been unsuccessful in reaching her because they want to confirm that she'd be moved from Arbor West to Arbor One and that she's okay with that, et cetera. So they just haven't been able to reach her. And Amy, if there's anything you wanted to add to that.
I haven't gotten any calls from them at all.
Yeah, I don't know if we don't have a correct number on Ms. Bannock, but I also posted something to your door. We just got an apartment available, Your Honor, that we can transfer her to, but we have to turn it. And we need to talk the details with her to see if it's something she would be interested in, because it's a completely different style price and area. So we needed to know if she would come into our office so we could discuss it with her. Would that be something
Okay.
she would be able to do?
I can do that. It's just nothing has been posted on my door.
Okay.
You gotta
Yeah, we
realize
kind of have
it's-
a problem.
Sure, we have
Yeah.
the right unit here because I know they posted something and I asked them to go back again yesterday. I mean, so something's not working here.
Well,
I would almost
unfortunately-
ask, Your Honor, if Miss Bannock has a telephone and she wants to call Amy right now, I don't want to just keep kicking the can here because it seems like we're having some communication issues.
Yeah, we got some bad kids in the building, so they probably ripped it off my door.
Okay.
Yeah.
That can
Bad kid.
happen.
Bad kids in the building. It was probably him. No. All right. So can you give her a piece of paper to write down her number? Because they may not have a good number. And I don't want to broadcast it out there. And then what will happen, if with your permission, we'll put your number in so that they can see your number and
Thank you
get
very much. And I'll reach out today so that we can talk about the details.
There is, how much is in escrow? There's a
$39.80. There was an $80 payment made yesterday.
$39.80. Okay. So in terms of what she owes, and even coming into April, I have $39.80 in escrow.
And I have a balance of $4,055.85. So we're very close.
Okay. So if we can get her moved, if I put this to the 12th, we should be all settled and everything and then be able to get this money out to you.
Okay. You know, I'd ask for
Okay.
you to release it right now, but I'm not going to waste my breath.
Oh, you can ask.
I know the answer. I know you will.
And I
enough.
want you to ask so I can say no. No. All right.
I don't feel like getting the rejection right now. Okay. Let's move.
Okay. April 12th, 2024 at 10 a.m. Okay. So they're going to get in touch with you. We'll get this done.
Okay.
Okay. Thank you. Court calls the case of Mauer Apartments versus Tia Owens,
Charles Friedman for the plaintiff, Your Honor.
AKA Teddy Owens. As soon as he'll get out of the way. Your name?
Tia Owen.
All right. All right, where are we on this case?
Well, Your Honor, we're at a pretty substantial balance, but Ms. Owens has made a smaller payment today, made a payment last week. She has applied with Hawk, but is quite a ways out. Is there anything you can add to that?
I did just speak with her and she's assisting me with getting a sooner appointment. My appointment wasn't till May 14th.
Okay. And so what's happening? Odd system. People who are here, when they call in and they have the appointment, what Amy's doing is talking to them, moving their appointment up to prioritize their case. I don't know why that system is set up. Do not look at me like I set it up, Mr. Friedman.
No,
I didn't.
I don't either.
So she's going to get a sooner appointment.
I'm all for April 12th.
Good enough. I'm a little gun shy because I had luck off first thing this morning. April 12th, 2024 at 11 a.m. Okay, ma'am. Thank you. And you've already talked to Amy.
Yeah.
Okay, fantastic. Thank you. Court calls case of townhomes on Robbie Lane versus Janella Smith. Been here all morning.
She's making progress too, Your Honor. She's made an escrow payment, going to make another one on the April 2nd. And so there seems to be a disconnect with DHS. They're claiming that my client hasn't furnished them with a W-9 and we have. So she's emailed me information that we can deal with DHS and try to get this straightened out. So to summarize, how about April 12th at 11 a.m.?
That work for you? How much is she owing at this point?
A lot.
Yeah. Okay.
I'm being honest.
No, I appreciate it.
I don't know if I have the ledger in front of me, but it's
It's in the upwards of about 5,000.
yeah, it's
Okay.
well, yeah, yes, period. However, with the escrow she paid and then the escrow that she's going to pay in April, it's not increasing.
Got it. I think that's what we're, all right. April 12th, 2024, 11 a.m.
Thank you.
All right, thank
Have a good
you.
one.
You do the same.
Okay. I don't know how to do things. I'm lost. It all falls apart immediately. Okay. Composure. Look, puppy dog. Say hello. Say hello. Puppy dogs. Hey, guys. I know. Need to calm down just a little bit. Right? Sorry. So, that was the end of our Simpson segment. Now we're moving on to our Boyd segment. I thought those Simpson hearings were kind of cool. I don't know. I got a little distracted there towards the end. I do apologize. I've got family who apparently forgot that I'm streaming today. But yeah, I thought those were some pretty feel-good segments towards the end right there with those landlord-tenant hearings. I thought it was kind of funny there where he mentioned that he was feeling a little gun-shy because he had been dealing with luck off all morning. I thought that was fairly humorous. That's part of the reason that got slid in there towards the end. But hey, this next segment with Boyd, earlier we were pointing out that one of our defendants walked up with his arms all crossed and serious with Judge Shackelford. Got another one of those, this time in front of Boyd. And let's see, the next person after that is a guy who I'm not sure if he's a vagrant or if he's just really likes to hang out in places that they don't want him to hang out and does what he wants to do. So yeah, let's watch some Boyd together. And just so everybody knows, I'm working on the whole saying making those stupid sounds. So bear with me. The lives will get better. Get a little bit more, I don't know, less rough. Anyhow, the Boyd.
George Cantu? Is the attorney here for George Cantu?
Yes, there you are.
All right, come on down. Court is calling counsel. You're on this side, your client's in the center. And you all act as though y'all trying to buy Diana's equipment. Court is calling 2024 CR 0411 State of Texas versus George Cantu. Can I have the parties announced for the record for the state?
Daniel Escobar from the state of Texas.
Defend.
Alfredo Ortiz for the defendant, George Cantu, Your Honor.
Are you Mr. Cantu?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cantu, I'm showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
Yes, we do, Your Honor.
State, are you proceeding on the indictment as presented?
Yes.
All right, as a habitual?
Yes, Your Honor.
And so this tampering with electronic monitoring device, what is that, a third degree?
It should be state field, but
Okay,
I was looking into it. I know that the statute does have the third degree language, but that's it. It was a instance of supervision. And there was no language like that in our side.
okay. All right. I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it?
Yes,
Did
ma'am.
you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with tampering with an electronic monitoring device under intense supervision? That's a
ma'am.
state jail felony, the way it's been indicted.
Yes,
The range of punishment normally would be anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
All right, you can unfold your arms. You get people nervous when you do that, okay? If the state is able to prove up the enhancement allegations, then this would be a second-degree punishment. The range of punishment would be anywhere from 2 to 20 years in prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in, the right to remain silent? Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
In my opinion, he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, he is.
Mr. Cantu, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea? Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney and did you understand it? According to the plea, punishment is to be assessed at 5 years in the prison. You agree that you've been convicted of 1 or 2 more felonies for enhancement, and there are no applications. Did you understand that to be the plea?
Yes, ma'am.
Did you review the paragraph entitled Waiver of Appeal with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, there has not, Your Honor.
And did you understand that to be the plea, a cap of 5 years?
That's correct.
All right. And state, is that the plea, the cap of 5 years?
Yes, yeah.
All right. And to correct the record, the plea offer is for a cap of 5 years in the prison. Did you understand?
Yes, ma'am.
All right. And to the offense is charged, how do you plead? Guilty, not guilty, or no contest?
Guilty, ma'am.
State, any evidence?
State offer states to the one in all passions.
Any objection?
No objection.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in, the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. And with regards to the both paragraphs of the habitual offender enhancement allegation, how do you plead, true or not true?
True.
And that's true to both of the enhancements?
Yes, ma'am.
All right, after reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. The court will find you guilty. The court will find the enhancements true based upon your plea of true and based upon states exhibits 1 and attachments. Do y'all wish to proceed with sentencing?
Yes, Your Honor.
All right, anything you wish to say on behalf of your client?
Yes, Your Honor. We filed a motion to reduce this state jail felony to a misdemeanor punishment, Your Honor, 1244A. We want the court to consider the circumstances regarding the offense, Your Honor. November 7th of last year, Mr. Cantu informed his parole officer that he had problems at home, that he was living with mom and he couldn't stay there no more. So he informed his parole officer that he was gonna take off, unbuckle his GPS monitor, that he couldn't stay there no more. That was November the 7th. He left the equipment there at his mom's house and that was not damaged or anything. 10 days later, November 17th, he self-surrendered to the parole officer. And he was taken to custody and taken to the Bexar County Jail, where he has been there since he was arrested, Your Honor. I want the court to consider that he is not a violent person. He has the criminal history that he has, a lot of that can be attributed to his drug abuse illness. He has never received any treatment for that, Your Honor. So we're asking the court to consider all these factors and sentencing Mr. Cantu, Your Honor, and sentence him to a year in the county jail, Your Honor. And I think Mr. Cantu likes to address the court.
All right, so legally, this cannot be a 1244. So you want to raise, I'm sorry, you're already under oath. So it says in the police report that the device was removed on November 7, 2023, and it was reported as being removed on November 8th. And when I say reported, that's not you reporting it. That's just parole became aware. So what would you like to say?
Well, I took the monitor off on the 7th, and the warrant was issued, I think, to the 8th, the next day.
Okay. And did you turn yourself in on the 7th?
Yes, no, 17th.
All right. Any questions?
What do you like to say to the judge regarding sentencing?
I mean, I just got a severe drug problem, a bad drug problem, and it really needs help, you know?
Is that why your mom didn't want you living with her anymore?
Yes, doing drugs.
Okay.
I'll pass the witness.
Nothing to say, Judge, just sorry.
All right. Well, what I can tell you is I've done parole hearings in my past as well. And I know, and you correct me if I'm wrong, all you have to do is pick up the phone and call your parole officer. And in actuality, I think parole is easier than state probation. So did you pick up the phone and call your parole officer and say, I'm in the throes of my addiction. I need inpatient treatment?
No, ma'am.
Did you call them at all, telling them that you needed help?
No, ma'am. Called them after, cut it off.
Okay. All right. This is what the court is going to do. The court is going to find you guilty. Court is finding the enhancements true. The court is going to sentence you to 5 years in the prison, give you credit for any time served, and this will run concurrent with parole. Showing you what's entitled defendant's rights. I'm sorry, trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand? All right, we can go off the record. So I want to let you know that I did listen to your attorney's argument. I always internalize what I'm hearing, but at some point you got to be responsible for your actions. You understand? All right, good luck to you.
Thank you.
You're welcome. Who is here for Albert Bishop?
All
right, where's Mr. Bishop?
He's in the box right there.
Come on down, Mr. Bishop.
Come on down. Here.
And probation, this is an application. Court is calling 2024 CR 1174, State of Texas versus Albert A. Bishop. Could I have parties announced for the record for the state?
Jason Garrett, hand your own.
Defense?
Charles Gold for Mr. Bishop.
And are you Mr. Bishop?
Yes, ma'am.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Bishop, I'm showing you what's entitled application for community supervision or deferred adjudication. Did you review that with your attorney?
Yes,
Did
ma'am.
you understand it and did you sign it?
Yes, ma'am.
Did you review the document entitled True Bill of Indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented? Mr. Bishop, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with the offense of stalking? That's a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine.
Yes, ma'am.
If you have a plea with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial?
Yes,
A
ma'am.
right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that Did you understand by entering this plea, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I think he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Bishop, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I believe so.
Well, I mean, either you are or you're
Yes,
not.
ma'am. Yes, ma'am. Sorry.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, there's a $1,500 fine. State recommends deferred adjudication. They're taking in consideration 727710. There's to be no contact with Tricia Robles, and you're not to be within 500 feet of Tricia Robles, and you're not to go to McDonald's at 101 Alamo Plaza and be within 500 feet of that location.
Yes, ma'am.
Did you understand?
Yes, ma'am.
Did you understand that to be the plea?
Yes, ma'am.
Defense?
It is, Your Honor.
State?
That is, Your Honor.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the agreement. The state is requesting that your community supervision be for a term of 7 years. There be a TAP evaluation, 200 hours of community service restitution, and no contact with Tricia Robles or McDonald's at 101 Alamo Plaza. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. State Exhibit 1 with all its attachments.
No objections, Your Honor.
Showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, court will find there's sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor. I would like to address the court about the fine.
Yes.
He's homeless. We would ask that you probate the fine, all of the fine, until he gets a job or gets set up. We would ask, since he's been homeless.
All right, why are you homeless?
Just doing things for my community, the homeless community, being an activist and prevent.
No. Why don't you have a place to stay?
I guess for people sake that I don't like being a burden to anybody.
No, I mean, if you get a job,
I know.
no, here's the thing, listen.
Yes, ma'am. Yes, ma'am.
If you get employment and get an apartment and pay the monthly fee for the apartment, guess what? You're not a burden. It's a business transaction. So why are you not engaging in business transactions for a place to live?
I have no excuses to give you. I'm in the process of getting that together.
So why are you homeless? Like, when does this start? Have you always been homeless?
The point of beginning to now, I've been homeless for about 3 years.
Okay, so what were you doing before you became homeless?
Couch surfing.
All right, so why don't you have a place to stay? I still don't understand why you're homeless.
I have no excuses to give you, and I present them to you. And now I do have a reason, a purpose to stay off probation, to pay for myself. I mean, invest in myself.
Okay, counsel, do you know why he's homeless? I mean, sometimes people are homeless because they start using drugs and people are just done and they say,
I think during the time, Judge, no, not necessarily.
I've been sober for about going on my 13th year. I've never done heroin. I probably smoke weed for my anxiety. Because I do have bad anxiety. A drug problem. I'm too poor to have a drug problem. not to make fun or anything.
Yeah.
I just don't have the money to invest into a drug.
So I'm trying to figure out, how can he do well on probation? What is his plan?
To get myself on the ball for probation.
But how are you going to do that?
Getting a job, if it even means for right now, getting paid on,
Didn't you say something about Haven for Hope?
Yeah, Haven for Hope, or the means to an end to get a job. I mean, that should be easy.
Right.
A purpose? Well, I had no purpose. I had no family to speak of, no kids to speak of, nobody to take care of. And when it comes to investing in myself, well, now I have a reason. So if you give me a chance, of course I'm gonna do what's right. I always do what's right.
All right, so here's the thing. No less than 2 times, this person at McDonald's said that you've been bothering her and she doesn't want you there anymore. Is GPS appropriate in this case?
I believe at least initially it should be, Your Honor.
I don't know about that, Judge. I think wasn't this filed at large and there was nothing going on at the time?
No, I really every time she says the name, I really can't picture who the person she's kicking.
Well, it's the person where you keep going to McDonald's at 101 Alamo Plaza. She said you were trespassing. She didn't want you there. And it says, victim advised that the same patterns of malicious behaviors were directed towards victim by suspect. That's you.
Yes, ma'am.
They're saying that you would criminally trespass from the restaurant and would typically direct these gestures at her through a large store front window from the sidewalk. These behaviors occur several times a month and cause her to feel unsafe and anxiety. And then that was in August, and you also have the one from October. So I think he needs to be on GPS. How old are you?
20, I'm about to be 52, man.
Yes.
If I really don't need to be on GPS because I really don't have nothing bad against her. She's a manager at McDonald's. Maybe I flicked somebody off through the window that was in there, but really.
All right. See, why are you telling me that she's the manager at McDonald's and you just told counsel you don't even know who she is?
Well, I don't know who she is personally to say, but I know after speaking to her, when she gave me, well, yeah, she's the one of the managers at McDonald's.
Judge, I just think that, I mean, we could delve into this, but I think that he's homeless, and I think I'm asking about the fine. And if we can waive that, and I don't think how he's gonna pay for GPS. I think that can graduate if we need that later on, but there's been times when it hasn't. I say he's gonna be washed over for a while.
He needs GPS. I mean, I understand the situation that people are homeless. I do. But that doesn't give everybody a pass to do whatever they want to do.
Can you give me a chance to prove myself before you put me on monitor?
No.
But then, don't I need to pay some residents for a monitor?
What I'll do is we'll see if the fees can be waived, but you need to be on GPS monitor. And we can't do a wait and see if you're going to do well or not. Because if you're back at that McDonald's, I want to know about it.
Okay.
And the only way to know about that, because you say you're homeless, is for GPS. And do not cut off this monitor. You understand?
So the GPS is just to see if I'm in the area of the place?
Yes. What type of GPS do y'all want? Partial tracking?
None.
Oh, it's going to be GPS.
I believe he's tracking so that, I mean, if he is homeless, obviously, But he should be, I think the state's position is that this particular McDonald's, this particular individual was scared for her safety. And I don't know if you read in there, Judge, is that one of the times this happened, an officer was standing with this individual when it happened.
Mm-hmm.
And so that's the brazenness of that in front of an officer is more concerning to the state, you also, John.
Can I speak on that?
I don't know. Does your attorney want you to speak on that? All right, it's a $1,500 fine. That'll be probated. 7 years deferred adjudication. There's to be GPS tracking. No contact with Tricia Robles. No contact with McDonald's at 101 Alamo Plaza. And you're not to be within 800 feet of McDonald. I'm sorry, you all asked for 500 feet. I think it should be 800. Any objection to it being 800 instead of 500 feet?
I wouldn't know where.
No problem.
Okay. And you're not to be within 800 feet of the McDonald's at 101 Alamo Plaza or Tricia Roberts. I'm sorry, Tricia Robles. There's to be regular reporting by Zoom or in person. Regular random UAs. Proof of employment within 45 days of release. There's to be no employment as a home health care provider or with minors. There's to be no unsupervised contact with minors. There's to be a TAP evaluation in custody. My understanding that's 2 weeks. Follow TAP recommendations. Field visits. 1 time per month for 3 months. And then at probation's discretion. Probation, is there anything else he needs? Yes. All right, and then there's 200 hours of community service restitution. That'll be waived if you are able to get a certificate or some type of education from a trade school or somewhere else. You understand?
Yes, ma'am.
Is there anything else you need from the court to be successful?
I believe I'm being released on, I have to monitor.
You are going to be in custody for 2 weeks for a TAP evaluation. Anything else that you need to be successful on this probation?
So I'm gonna be put back in jail for 2 more.
Yes, you are. Anything else you need to be successful on this probation?
Okay, so do I was
Showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that with your attorney? Did you understand it?
Yeah.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
partially.
All right,
So-
what don't you understand?
When I'm gonna be released.
What I told you is you're going to stay in custody
Mhm.
for the TAP evaluation. Once the TAP evaluation is done, if the TAP evaluation recommends that you go into inpatient treatment, you're going into inpatient treatment. If the TAP evaluation recommends that you be in outpatient treatment, then you will be released.
Okay, and that could be up to 2 weeks.
It depends.
Okay.
All right, thank you. Stay away from there. You understand?
Chelsea? Can you get up on me?
Well, there you have it, ladies and gentlemen. Judge Boyd putting the hammer down. And that guy just was not getting, I mean, he was doing it in front of the police officers at the place. What you gonna do? All right, well, man, this has been a blast. Those are all of my segments that I had picked out. I hope you enjoyed them. I enjoyed watching them. They were interesting to say the least. Yeah, this is gonna be just to like let you guys know how this works. This live program is actually going to be cut up into different segments and released as independent, isolated videos for the people out there who don't like to watch the like hour and a half, 2 hour long live streams. I know there's a lot of us who do enjoy that, myself included. I love going to Mike's live streams. I love going to, you know, in particular Biggin's live streams. I don't actually talk all the time, but I'm in those live streams a lot. But there's a lot of people who are also like me that don't have time to watch all the live streams. So what I'm going to do is I'm going to take these segments and I'm going to actually segment them out and make, you know, independent little 30-minute videos out of the segments and that type of stuff. And so we'll actually have these segments in video format in the regular playlist in addition to the live stream. I may actually separate the live streams into their own playlist. That's something I'm kind of playing with in my head, just to let you know kind of what I'm thinking about as far as, you know, some of the channel stuff goes. But I haven't really decided on any of that type of stuff yet. But in any case, it's been a lot of fun hanging with you guys. Jane, I'm really sorry. We're at the end of the program, and I want you to rewind and watch it, you know, on replay and enjoy as much of it as you want to. We're going to be doing these every Saturday at the same time. It's going to start at 11 p.m. or 11 a.m. not p.m. 11 a.m. Central Standard Time. That's noon Eastern Standard Time. I believe that's 6 p.m. for our friends in the UK. So I want everybody to know that this is going to be a regularly planned live stream, so you can show up. It's what you saw today is my general idea for the live stream going forward. If anybody has any suggestions, I would really love suggestions on these live streams. Please leave them in the comments below. And let me know what you would like to see, how you would like to see things done, because I'm still really playing with this format a lot. So, till next week, I love you all very much. The dogs are here, and they love you very much. The cat could care less about any of us, but we're all fortunate to have him around. I'm your Lone Wolf Usul. I have been your host for today's live stream, and this has been From the Gallery Live. I hope you all have a great rest of your weekend, and however you celebrate Easter or the holidays, I hope you have a great holiday. Thank you all for coming out. Thank you all for coming out. Thank you all for coming out. I hope to see you next time. Have a good day. Thanks for modding, Dreams. You're awesome. Dreams and Wi-Fi is awesome. Everybody knows that, but if you didn't know that, you need to know that. Dreams and Wi-Fi is awesome.
Like two different